Morning, Glory and Evening Grace, America. I'm Hugh Hewitt. Welcome to Hour 3 of today's program. As you know, I've been talking nonstop shutdown, but some stuff keeps going on. And one of those things is the Supreme Court. And over at the Supreme Court, they've accepted an argument, for example, on whether or not President Trump can fire a Federal Reserve Board member for cause, alleged mortgage fraud. They got lots of cases coming up. And our friend Kristen Waggoner, who leads the Alliance Defending Freedom, our favorite legal defense fund in the United States, joins me to let me know what ADF is up to and what they're not up to because of the environment that has been created in the United States after the murder of our friend Charlie Kirk. Kristen, welcome. It's good to see you. How are you, and how goes the good fight that you usually seem to win in front of the nine?
Well, we never assume that that's going to happen, but we do have 4 cases before the Supreme Court this term, which is a record for us. But it's also a different year in the sense that it's our 13th year in a row with a case before the court, and it will be the first year that we've actually had to ask rally sponsors not to come outside the court because their safety will be at risk, which makes this very different than any other period where we've been before the court.
Well, that is very sad. I understand that the Supreme Court cannot provide perimeter security. My goodness, that would raise lots of First Amendment issues right there. But I know that usually that is a place where both left and right plaintiff and respondent always are able to get their word out. Is there a backup indoor secure space where the media can come talk to you after you argue?
We are providing different backups to do media and to ensure that the word gets out on what the case is about, because we know that in these cases, which are involving specifically gender identity, free speech, two of our cases has to do with women's sports, that there will be a lot of manipulation in terms of mischaracterizing what the issues are about. This particular case will be heard on October 7th, and it's called the Chiles case. It's about whether licensed counselors can have voluntary counseling conversations with kids who are uncomfortable with their bodies and want to talk and be listened to hopefully grow comfortable and at peace in their bodies.
So, did you win below or did you lose below on behalf of the licensed therapists and teachers who want to be able to talk to kids?
Well, I'm guessing you can probably guess at how that went. A lot of times the court takes these cases in order to fix what happened below. And so we did lose on this case below. It's in the 10th Circuit. We have a long history with the state of Colorado, and this is just one more chapter in that history.
Is that circuit never going to, is it the new 9th Circuit? You know, 9th Circuit used to be predictable, but the 10th Circuit used to be kind of normal when Judge McConnell and a few others were on it.
It's deeply disturbing what's happening there, and especially in Colorado. Again, what's important about this case is that it is involving counseling conversations, just listening and talking to kids. That's it, just hearing them out and helping them grow at peace with their body and realigning their identity with their God-given sex. And Colorado has a one-way ratchet that says you can't have those conversations. You can't help a child achieve their goal. Instead, you have to read from the state's talking points. And in fact, the law actually says that the counselors can have these conversations with kids if they transition those kids, if they affirm that they are born in the wrong body. And that's not even supported by the science. We know from the Scrimeti
I've been
decision,
going to Colorado
the Supreme Court
for 25
decision.
years. A quarter century of going to Colorado, and it's gone left every year since Bill Owen was governor. And I don't know why, but it's because the Californians, where it became too expensive, moved to Colorado and brought their politics with them. Good luck on that. Are you going to argue that one, Kristen Waggoner?
Oh, I wish, but no. Jim Campbell's going to argue it. He's our head of U.S. Legal now, and we're expecting a victory. It's a pure speech case that involves just government censoring a point of view, which is classic viewpoint discrimination.
Now, I have to ask you, because I had a chance to interview Justice Barrett twice in the last month, in September, and both times we talked about the Smith decision and specifically her concurrence in Fulton versus City of Philadelphia, where she said, hey, basically, I'm paraphrasing here for the benefit of everyone listening, this Smith test has got to go, but we got to replace it with something. Will someone come up with a test, please? And in both cases, at the Nixon Library and on this program, she said, and the scholarship has not yet arrived. Do you guys have scholarship that you're working on to give her a replacement for Smith?
We are working on it, and I do think that the strict scrutiny standard is probably the best standard that we have in place. And if courts actually apply it consistent with history and tradition, religious rights will be protected. What we have right now is almost a lemon situation where the court knows that the Smith test doesn't work, that it's not protecting rights, and that it really isn't based in history. And so they're simply ignoring it and sidestepping it, which is what we have seen in a number of cases recently involving religious freedom is a sidestep or creating an exemption. But again, if the court could just even get back to just applying strict scrutiny and treating religious freedom as a fundamental right as free speech is, those rights would be protected.
And that might be the argument to make. I was just surprised at her candor that no one had risen to the challenge yet. And of course, she had to recuse in the Oklahoma case. I am waiting to see what happened. When are the other three coming up, Kristen? Are they in the new year, or are they later in the term?
They are in this term. So we have a case called First Choice, which is involving blue state attorneys general that have been harassing pregnancy resource centers by issuing them subpoenas and other using investigatory tools to harass them and try to get their donors, and without any findings of fault or even allegations or complaints filed. So the court's going to hear that case hopefully in December is what we're told. And actually we have bipartisan support, cross ideological lines, even the ACLU supporting that case, because we have seen subpoena power be used in oppressive ways that force people to not be able to get into federal court to adjudicate their federal claims. So the other cases that we have are likely to be argued in January, and those are two women's sports cases. As you know, a majority of states have passed laws to protect women's sports and say that states can essentially make sex-based distinctions on athletic teams, and those laws are being challenged by the ACLU.
Oh, good luck to you on all those. I want to close with one last question. On the question of courthouse steps communication in an age of crazy people who assassinate people they don't like, is there any conversation with Pam Bondi or with DHS about establishing a free speech zone around the court so that people can enter and leave safely and have their... It's good for the media, it's good for the litigants. Is there any conversation with anyone going on about that?
We are having those conversations, and we're hopeful that we will be back in front of the court for the women's sports cases in January. But right now, it is just not safe to have an event outdoors without additional security measures, and there's simply not time to figure that out in this moment. And I just couldn't live with myself if someone got hurt.
No.
It's not going to be the people inside the court. It's not going to be us who are litigating it. It's going to be the people that come to express their First Amendment rights. So we just need to figure this out and hopefully de-escalate some of this. I mean, we've been receiving all kinds of death threats and other threats personally and to the organization, especially over this gender identity issue and post Charlie's tragic assassination.
So prayers for you and your team at Alliance Defending Freedom. People can go to adflegal.com to help them out, and we will talk to you again after the case is argued next week and then before the next three, because it's always a joy to talk to you, Kristen. Thank you for joining me today. Kristen Waggoner, CEO and President of the Alliance Defending Freedom. Thank you, Kristen.